بسم الله الرحمن الرحيم الحمد لله رب العالمين وصلى الله وسلم وبارك على سيدنا ونبينا وحبيبنا محمد قائد الغر المحجلين وعلى آله وأصحابه وأتباعه إلى يوم الدين. اللهم فقهنا في الدين وعلمنا التأويل وألهمنا بفيض فضلك رشدنا يا رب العالمين. Alhamdulillah, in our lessons on our course on Imam Ibrahim al-Halabi's Multaqa al-Abhur, we are completing today the section on Riba by looking at one key issue, which is the issue of Riba in al-Harb, and then looking at the chapter on rights and responsibilities بإذن ta'ala. باب الحقوق والاستحقاق. Okay. And we will see a number of important principles today related to some of the outcomes of the course, which is that particularly this issue here of Riba in al-Harb highlights the issue that there's a difference between understanding what the text says and what it means, and what underlies the ruling, and how a ruling is applied. Right? Because just understanding the text can be actually quite dangerous, which is why one of the great late Hanafi commentators, post Ibn Abdin, al-Atasi, in his commentary on the Majalla, in a few places he corrects the Christian commentator on the Majalla, namely Rustum Baz al-Lubnani, who was a Christian commentator on the Majalla, the Ottoman Hanafi law code. And so he has this beautiful expression. He says, فَخُذْ هَذَا التَّحْقِيقِ وَدَعًا كَمَا قَالَهُ الشارح رستم باز. So he said, take this verification and leave what the commentator Rustum Baz says, لأنه يتمسك بالمباني ولا يدرك المعاني, because he holds on to, the mabani here meaning the expressions, and does not realize, i.e. fully, their meanings and implications. So this is a very important concept, right? Like إنما يؤخذ الفقه من الفقهاء. Fiqh is taken from the people of fiqh like any other science. So what we'll be explaining today is what the ulama of tahqiq have to say about some sensitive issues. Okay. And we'll also be looking at that just because something is in a matn does not necessarily make it the relied position. Right? That's one of the things. And for you also, of course, to have a map of relied upon positions where the ulama have talked about. And we would encourage you to look up some of these things. And in relation to that, we have been giving you some recommended readings, particularly those of you who are able to access the primary text. This is one of the benefits of such study, and that's where it is upon you, and you get a return on your effort by putting in that extra effort. We have now, alhamdulillah, shared this important resource as well on the prohibition of riba. It's now in the course materials and under the previous lesson, correct, Sidi Abdul Latif?
Yes, I'll double check to make sure.
Yeah. So it should be not just under the general resources, but for the resources for this particular for this particular lesson, the previous one on riba. Okay, and
yes.
And then today there are a few critical outcomes that we will be touching upon. One is, this is probably the most important, which is the first part, to contextualize the discussion on riba being permitted in quote-unquote al-Harb. And then we'll look at the issue of rights, which enter into different property sales. Because there's a problem with property, which is the challenge of who owns it. Particularly in the context of families, you'd have extended families. Someone would get wealthy, and one of the ways to be generous is that they would let family members live in property that they had accumulated. But then people die, right? So the issue comes up, who actually owns that property? Does something become yours just because you got it from your parents and they got it from their parents? Does it just automatically become yours, Sadati?
No.
No, right? So this is where the issue of istihqaq comes in, which is ظهور حق ثالث, when a third party's right becomes manifest. One of the places where this is most common, although it comes up in the sale of commodities too, but when it comes to land, that you sold something, someone sold property. They thought it was theirs, but then turns out that it wasn't theirs. It actually belonged to their uncle, who had let their father live in that place. So there's the seller, the buyer, and then there's the issue of istihqaq, ظهور حق ثالث. So what do we do in this? But then someone could buy a property to resell it to another. So it gets messy. So these things are quite common, and if you deal with even within family, etc., which is why across the world they establish this notion of registering property formally, and in dispute, giving precedence to the property registers because of that. So we'll be touching upon that as well. And these are very common issues. And then in that, so we look at this issue of third-party ownership and the rulings of unauthorized third-party transactions as well. These are called bay'ul fuduli. What is fadl in Arabic? The word fadl, what does it refer to, Sadati?
Ziyada, increase.
Right? Ziyada. A ziyada, right? Increase. And if it's increase in the good, it's called fadila. But increase in the negative sense, it's called fudul. Right? So the fuduli is man tasarrafa bighayri idhnin shar'i. Someone who transacts without shar'i right. Someone who transacts without shar'i right. That's the fuduli. And as you should be aware of from prior study of Hanafi fiqh, the tasarruf al-fuduli sahih. Right? The transaction of the one who acts without right is valid, but it is considered mawquf, suspended. What is it suspended upon? Suspended upon the permission of the one whose right it is. Because there could be an interest. So let's say that you live in your uncle's house, but your uncle went away on a long vacation. He's been trying to sell this house for a long time. He never asked you to sell it. But suddenly, these tourists came to the old city of Damascus and they want to purchase that house because it's right next to the new Seekers Guidance Center near the Umayyad. And this wealthy gentleman or this wealthy lady, she inherited money from her husband passing away from her good cooking. So Auntie Jamila, she cooked really good food, but her husband died young as a result. But she inherited a lot of wealth. She decided to move to old Damascus. Anyways, long story short, she wants to buy this place. She's willing to pay extra because she realizes. So if you sold the property without your uncle's, and you can't reach your uncle's gone on da'wah. There's a group called the SDG, the Sunni Da'wah group. They do Jamaat Tabligh, but they hold mawlids and stuff. Anyway, he's out and he's practicing the Seekers Guidance seminar on ihsan, mindfulness in the digital age with Sheikh Adham al-Asimi and myself. So he's disconnecting for these 40 days. So you sell the property. Is that valid? And those of you who are joining us online, you can comment as well. Is it valid to sell your uncle's property?
No, without his permission.
Is
I
it
think you can
valid?
sell it. Sheikh,
Okay.
Sheikh, from my understanding, is valid, but it is mawquf on him coming back and basically saying, I agree with it or I don't.
Yeah, so there's two aspects, right? So the harm in such a transaction is that if you sell someone else's property, the default would be that you're acting without permission on someone else's property. So the harm is that they may not accept it. There may be harm on them. That yes, they may be poor, but they don't want to leave old Damascus. There's a harm, but there's also a potential benefit. He was desperate to sell the place because he needs to move out for whatever reason. So in this kind of scenario, and there's of course textual basis, etc., but we're looking at the legal rulings themselves. The transaction is valid because the integrals of the sale are found in such a transaction. And there's two transacting parts. If you look, صدور ركنه من أهله على محله. The integral of the transaction is found. There's two transacting parties. There's إيجاب قبول, etc. صدور ركنه. So there's an إيجاب قبول. صدور ركنه من أهله. And there are these two people. So there's إيجاب قبول from two people who are in of themselves fit to transact. And the conditions, the ulama are very careful in how they phrase things. There was no specification that you have to own you have to own what you sell for validity. It is owned, right? And it's not yours, and it's not yours. It is owned by the person on whose behalf you're selling. So anyways, all those are found. So it is bay'a. The later scholars use much tighter usage just to clarify things. So they said this is bay'un mun'aqid. Bay'un mun'aqid. Right? The sale takes place. As opposed to, because sahih, there's a confusion that would arise for the untrained. That's sahih. Does it mean it is valid or is it sound? Right? Because sihha can relate to validity or soundness. So you use the term mun'aqid, right? That it takes place. Right? So it is valid, but it is not sound. Right? In the sense that it is mawquf. It is suspended on the permission of the owner. In the general case, as we will see, unless you have غلبة الظن, unless you are reasonably sure that they would approve of this, you should not enter into it. Right? Because of the hadiths about a person's property is not permitted except by their willful permission. We'll also highlight a few key concepts. One of them is what is meant by Dar al-Harb, enemy lands. And the distinction between a bayt, manzil, and dar in the usage of the fuqaha. And we've touched upon some that earlier as well. And also the idea of third-party rights or the arising of third-party rights. ظهور حق ثالث, استحقاق. And we'll be looking at the fuduli that we've been talking about. Some of those are some of the key concepts. Now, this is very important. بإذن الله تعالى, this issue of riba in Dar al-Harb. Riba in Dar al-Harb. So let's give you the executive summary. This is not a murder mystery. Saying that riba is permissible in Dar al-Harb is a misunderstanding of Hanafi fiqh. Saying that riba is permissible in Dar al-Harb is a misunderstanding of Hanafi fiqh. Why? Because firstly, if you look at it textually, what's the nature of the prohibition of riba? How is it established?
through the Quran.
في نص القرآن متواتر.
Yeah, there are explicit Quranic texts on the prohibition of riba. So they're not just قطعي الثبوت and قطعي الدلالة, they're not just decisively established and decisive in their indication, but they are من آكد النصوص. They are the most emphasizing of texts. And relating to prohibitions, there are few prohibitions. After shirk, it's hard to find anything that is more grave than engaging in riba. Okay. Then, what are the primary texts? Yani Quran, Sunnah, Athar of the Sahaba, permitting that say that there's not riba between a Muslim and a Harbi in Dar al-Harb. Right? And this is also why it is very important that yes, we follow the method of the fuqaha and we take, the tartib of fiqh and fatwa from the transmission of the madhab, but that transmission can never get disconnected from the primary texts and the reasoning. Even though for fatwa, most people, are they really looking for deep reasoning from they come to people, and the faqir has been answering questions now by my teachers' command for the last 24 years. Are most people looking for, if they're going on umrah, the reasoning for why this is fard and this is wajib and this is just recommended? No, they just want to practice. But if we do not understand where are the primary texts from, and what primary text is based on, what is the reasoning underlying this, and we don't understand it with some depth, then we can misportray what it affirms. So the direct texts saying that لا ربا بين مسلم وحربي في دار الحرب, these are from the explicit texts they're from Mursal Hadith. The Mursal of Makhul, for example, with the text that Abu Hanifa used, that لا ربا بين مسلم وحربي في دار الحرب. Now, is that text قطعي الثبوت, decisively established?
No, it's not.
No, it's it's sound, and there's other supporting texts that that some of the Sahaba who were in Mecca, they had engaged in in ribawi transactions at that time, etc. But the thubut of that is dhanni, and the dilala of those texts is at best dhanni. Right? That which can be affirmed to them is equivocally affirmed. So, can the meaning of لا ربا بين مسلم وحربي في دار الحرب, that there's no riba between a Muslim and a Harbi في دار الحرب, be for prohibition? That لا ربا محرمة, there's no riba that is haram between a Muslim and a Harbi في دار الحرب. So that those dhanni texts condition the firmest of prohibitions. That would be deeply problematic. And of course, this text, part of its dilala is particularly dhanni. Why? Because what is missing in the text, la riba, like think grammatically, la, what kind of la is this, folks?
نافية للجنس.
Yeah, it's a la nafiya, la riba. So can you understand the text at face value? What is missing in the text? لا ربا, right? بين مسلم وحربي في دار الحرب, that's something else, right? What is missing in the sentence? One of the umdas of the sentence is not there. What is it? La riba, what is being negated with respect to riba is unstated, as is the usage of the Arabs for many things, right? La riba. But what is the taqdeer there? Is it la riba muharramatun? No riba is haram? Or is it la riba mawjudatun? No riba exists. بين مسلم وحربي في دار الحرب. If we were to say that la riba muharramatun, we are conditioning decisive texts on the basis of what? Of, at best, dhanni texts. That's very, very problematic. And then the issue of taqdeer, when something is implicit, the asl in the Hanafi school is that if something is implicit, then taqdeer is considered darura. You have to say that something is implicit. This is out of necessity. So one affirms the least, which would be la riba. In this case would be la riba mawjuda. No riba exists. And why does no riba exist? Because the reasoning that they give, right? Because the reasoning that they give, right, is like, if you look at Maulana Sheikh Zada, what does he say in Majma' al-Anhur, Sharh Multaqa al-Abhur? He says, لأن ما لهم مباح في دارهم. Their ما لهم مباح, what does that mean? That ما لهم يملك بالإباحة. That their property is owned by ibaha, by permission. How is other people's property normally owned? The normal way. Like it's either they gift it to you or there's muawada, right? There's aqd. Right? And they're very, right? So there is no contract. And of course, and there's also the danger of simply reading this more mukhtasar works, right? Because there's a lot that is implicit. And we will be sharing, I've gathered many, many texts related to this, been working on this for a long time. Their wealth is mubah in their lands, but doesn't mean mubah that you can just take whatever. Mubah ay yumlak bitariq al-ibaha. It is owned by the way of permission. It's like if you go to eat at someone's house, the food in front of you, do you own it? No. Can you just take the biryani, right, put a lid on it and take it home? No, because it is owned bitariq it is, you have it bitariq al-ibaha, by permission. They've allowed you to eat from their food. So even if you put it on your plate, do you then own it? No. And it gets tricky. Nobody really typically, but like if you put all the meat on your plate, do you own it now? No. So they could actually revoke the permission. So that's what ibaha refers to, right? So فبأي طريق أخذه مسلم أخذ مالا مباحا إذا لم يكن غدر. Right? As long as there's no غدر, there's no cheating of them. And the reason for all of this is that there's no aqd between you and the kafir in Dar the kafir, yani the harbi in Dar al-Harb. Right? Because you enter into enemy lands as someone who does not have legal recognition. So there's no aqd between you. Because what is the basis of a aqd? What's the difference between a contract and a promise? What can you do with a contract? If I can prove that I purchased this phone from Uncle Latif, what can I do? As opposed to, he just said, yeah, you can use my phone. What is the difference between it?
An aqd is enforceable.
Yeah, aqd, amongst the characteristics, is at least theoretically enforceable. But if you are not recognized. If you are not recognized, that who are you, right? Then, so there is no aqd between you and a non-Muslim. Given that there's no aqd, no riba arises. Why does no riba arise? Because we took the definition of riba last time. What is it? It's فضل خال عن عوض في معاوضة مال بمال. Right? It's an extra that is not associated with recognized consideration in an exchange of wealth, of an item of value for an item of value. So given that there's no contract, no fadl arises. One person just said, take this, and the other person said, okay, I'll give you this. So it's a non-contractual exchange, which is also why you can engage, you can sell, you can quote unquote sell impermissible items. Because you just picked up this pork and someone agreed to pay you. You can engage in gambling, qimar. Why? Because there's no contract. Because you can engage in buyur fasida. Why? Because is there a contract? No. So if there's no contract, it is not a bay'a fasid. And because you guys agreed to some things and say, okay, you take this, I'll take this. Does that sound like the reality of what takes place if you enter into a contract with the bank?
No.
No. Right? If you end up at the end of the world, they're going to chase you down. Right? Right? So this is the underlying issue, right? That it's not that no riba is prohibited, but rather that no riba exists between a Muslim and a non-Muslim, between a Muslim and a Harbi in those lands. And we'll share many texts that affirm this, because there's no isma to the mal there. But if you have legal recognition in those lands, if there are contracts there, then there is riba. And if there's riba, it is prohibited. Can you engage in buyur fasida in these lands? No. Because these are contracts. So you cannot engage in buyur fasida. Can you engage in gambling, sell pornography, sell pork in your supermarket? Because those are sales. If you said, no, it's not a contract, the distributor just dropped it off and I said, I'll give you some money for it, it's a contract. If you didn't pay up for that pork that you said, no, in Dar al-Harb you can sell pork and you can sell wine, because it's not really, because these uqud al-muharrama aren't haram. Firstly, just think of Muslims engaging in all the vices, whereas there are wisdoms for these prohibitions. So this is an error in fiqh. Sometimes it takes people time to come around to understanding these things, but it's also the danger of shallow comparative fiqh. It's shallow comparative fiqh, that we just read what the text of a madhab says, but what is their basis, understanding, what do they presuppose, what is them, what are the principles these are based on? Without understanding those, we end up saying absurd things. So that is a little bit of background on this issue. And let's see what the masala itself states. Right? Riba and Dar al-Harb, he says, وَلَا رِبَا بَيْنَ السَّيِّدِ وَعَبْدِهِ. There's no riba between a master and servant, because the bondsman and his property belongs to his sayyid. وَالْمُسْلِمِ وَالْحَرْبِيِّ فِي دَارِ الْحَرْبِ. right? يعني ولا, so the عطف is to the nafi, right? ولا ربا yeah, ولا ربا عفوا ولا ربا بين المسلم والحربي في دار الحرب. So again, there is an expression and there is its meaning. What does Dar al-Harb mean? You say, well, no, Hanafis have a dual classification. There's Dar al-Islam and there's Dar al-Harb. Okay, if they do, is that a revealed classification? That it could only be this way? Let's just say, if we simplify, if by the time of the passing of the Prophet ﷺ, there is only Mecca and Medina, that's it. Right? So the only state that there was with Dar al-Harb, the only relationship with a non-Muslim polity was Mecca before its conquest. Does that mean that the ahkam of shara have no other application outside? That's, that would not be considered credible, because there are other suwar. So even if you say, well, they classified in two ways, then it does not follow that every ruling that Abu Hanifa rahmatullahi ta'ala alayhi, al-Imam al-A'zam, said applies to Dar al-Harb, applies to this Dar al-Harb if the situation changes. And if the reality, there's musamma Dar al-Harb and there's haqiqat Dar al-Harb. There's that which is called Dar al-Harb and there's its reality. So presupposing that is that the Muslim, there's no hurma, right, to the Muslim and their property in those lands, except insofar as they just let you be there. But there's no, so one enters there temporarily, engages in transactions, one leaves. So and that's why when it comes to a harbi entering our lands, if they enter bi aman, then what happens? They say, لأن ماله صار محظورا بعقد الأمان. Because if they enter our lands, we give them aman, we recognize their presence, their rights in our lands. So therefore, you cannot have riba between a Muslim and a non-Muslim of Dar al-Harb in our lands. Why? It's not because of the place, but because of the reality relating to that space, right? Because of the realities related to that space. So this is the ruling. Given this, when this issue arose, some of the great fuqaha, they solved it in the path of least resistance. They said that in our times, we have to give fatwa on the position of Abu Yusuf. The fuqaha like practical solutions. Look, there's khilaf between our three imams. Abu Yusuf said, riba applies. Applying anything else with the presence of Muslims in non-Muslim lands and they're living there has grave harm. And there are many examples related to that with other matters, right? Where the fuqaha would affirm that there is, that the fatwa is necessarily on a particular position. We'll be coming soon to when we cover salam, we'll be covering istisna. Right? The fuqaha, people who know contemporary transactions of the fuqaha, would say that someone who says that the transmitted position of the madhab, what is it regarding manufacturing contracts? That they are non-binding. They're valid but not binding. They took a lesser secondary narration from Imam Abu Yusuf that these are in fact binding contracts. That's not Zahir al-Riwayah from Imam Abu Hanifa, nor from the Sahibain. Why? Because saying the contrary has evident harm. So one simple line of thing is that the fatwa is necessarily on the position of Abu Yusuf. The other is that this is an ikhtilaf of asrin wa zamanin wa makan, that this is a ikhtilaf due to differing realities, and therefore, if Abu Hanifa was in our times, he would not say that there's no contract taking place between you and a non-Muslim in non-Muslim lands, right? In Dar al-Harb. So that is, and we will share some of the resources related to this, bi'idhnillahi ta'ala, and saying otherwise, someone who engages in riba in non-Muslim lands, they're, at the very least, whether they're ma'zur, right, with Allah subhanahu wa ta'ala is one thing, but rulings have harms. Not just worldly, rulings relate to benefits and harms, both related to the next life and this. Just like if you're sitting in a room and you're not doing drugs, but other people are smoking and you're inhaling the smoke, will you be affected by it?
Undoubtedly.
Yeah. Right? You will be. Now you might not be sinful. You're stuck there for some reason. But you'll be affected. So similarly, even if you took the rukhsa, does that absolve you of the worldly and potentially some of the spiritual harms related to that? Right? Right? And the someone posed a comment, after calculating rent and fees, I found that the Sharia bank was almost the same interest rate with conventional ones. That is irrelevant. Even if every Sharia solution was 25% more expensive, would that permit the conventional solutions? No, it wouldn't. Like is the same quality, at the same quality, is zabiha meat cheaper or more expensive than regularly slaughtered meat?
More expensive.
In most places you expect it to be more expensive. That has no relationship to whether something is permissible or not. Right? Is, say at the same quality point, a sister wearing, for example, who wears jilbab, are jilbabs more expensive than similar quality fashion purchased from a supermarket? Like a proper, jilbab that is loose, dignified, you would expect it to be more, the jilbab to be more expensive at a similar quality point, cloth, this and that. Why? Because the market, those are simple, that's simple economics. So that is not a consideration whatsoever. Right? There's a cost of being Muslim, right? That's not the fact. And when it comes to finance, one has to understand, if a market is smaller, there'll be greater risk. Right? The risk of default is spread over a smaller pool of people. So it's likely that you are going to, investors are more worried about Islamic investments because they're not familiar with them, risk, both in terms of those investing, want higher returns if they're investing with an Islamic project vis-a-vis, conventional investments, quote unquote. So you expect that there'd be, that the cost of financing would be higher for them and the risk of giving out the financing would be greater. That has nothing to do with the prohibition of riba. And the fact that there's a resemblance between sound Sharia compliant financing and riba, Allah subhanahu wa ta'ala waves that argument aside. قالوا إنما البيع مثل الربا. They said that trade is just, it resembles riba, because in both there's exchange involved and there is an increase. But this is a permissible increase and this is an impermissible increase. So Allah says, حَلَّ اللَّهُ الْبَيْعَ وَحَرَّمَ الرِّبَى. Allah has permitted trade and prohibited riba. So that is not relevant to the matter, and the fact of the firm prohibition of riba and its consequent elements would make a person, want to desist, and the harms of that those who consume riba stand only as one driven crazy by the touch of the devil. Right? Those are some pretty serious things that have implications on us as individuals, our families, our communities, and the level of the ummah. Right? At the level of the ummah. So, Nasallallahu al-lutf wal-afiyah. There was a raised hand. Go ahead.
Assalamu alaikum, Shaykh. Shaykh, I just had a question, just to make sure I understand. So the reason that the reason that this hadith, or rather this principle, right, doesn't apply in a non-Muslim country today, is that because of the nature of the contract with the bank, or is it because, and that's like a full, proper contract, or is it because he's like a Muslim musta'man with citizenship or with a green card, like he has safe passage? Is it one of those?
In our lives, can we credibly say that, let's say if you're renting a home, that it's not a contract, they just let you stay there and you just agreed to pay them? Is that describing reality?
No. Usually it's a contract. It's a back.
No, it's a contract. No, it's a fact. These are contracts. Yes. If you have a cell phone plan, it's just a matter that they let you use their access to the network, and you just agreed to pay them just as an involuntary thing, or is this a contract?
It's a contract. So it's the nature of the contract is what you're saying. It's not the fact that you're a citizen.
Yeah, la riba, like la riba, it's not that it's la riba muharramatun, right?
It's mawjood, right?
لا ربا موجودة. Why is no riba موجودة؟ لأن أموالكم لا تملك بالمعاوضة. These are the expressions of the fuqaha. Their wealth is not, there's not, the transfer of ownership of their wealth is not through a contract of exchange, but rather it's بالإباحة. That's when say لأن أموالهم مباحة. It's mubaha does not, because you cannot lie and cheat them. Why? Their amwal is mubah, i.e. you take it bil ibaha. If they let you take it, you can take it. Mm-hmm. But saying that all our transactions, if I went and purchased this cap, that the guy just let me take it and I just agreed to give him some money, but it wasn't a contract. That is afactual. And then one can analyze. The fuqaha described what is considered a contract. Okay? ما يصح مطالبته. Like, what's the difference between muawada, a contract of exchange, and simply lending something, or ibaha? The biggest thing is enforceability. Right?
Makes sense.
One of the biggest things. So that's how the issue arises, right? But saying that everything that we do is not a contract. Right? So your employment contract, and then we call it a contract, but it's not. Right? Even we affirm, right? If there's a relationship between words and meanings, then no, it's not an employment contract. They just agreed for you to do some work for them. You agreed to do some work for them, and they agreed to pay you. At the end of the month, if they don't pay you, do you have any, at least theoretical legal recourse? Of course. Okay. So that
can I ask one more question?
Yeah, go ahead.
So when Imam Muhammad Shaybani, when he basically said that you can only assuming that you can take the wealth of the Harbi and the al-Harb, right? In that case, right? He said that it's only when you take and not when you give. When people and I have some
So that's a separate discussion. That's a derivative discussion, right? Why? Because the first thing is that what is the nature of that exchange? right? That once we agree on what's the nature of that exchange, then we agree, okay, what are the parameters of that exchange?
Makes sense. Got it. Yes.
Right?
And you're basically saying that the nature of the exchange has not even been
Yeah.
has not even entered into that discussion at this point. Okay.
Right?
inshallah.
So it's like, if we say, okay, employees, male employees can use these washroom, female employees can use these washrooms. So I walk into the place, I say, well, I'm male, I'll use these washrooms. No, there's something before. It's for employees only. Right? They're just being polite. Washrooms for male employees, washrooms for female employees. Right? I just walk in, I'm going this way. No, but there's a condition meaning. Firstly, what is the nature of this transaction? Then what are the parameters for those, right? And the parameters for those, they said no, because there are many governing principles there. The idea of al-Islam ya'lu wa la yu'la alayhi. And if you're in a non-Muslim land, don't allow yourself to harm yourself or harm. And very often, trade would be in the context of caravans. People, when they would travel, would frequently travel, trading on behalf of investors. So, you're in hostile lands. Right? Do not enter into transactions like these when it's to the disadvantage of the Muslims. Right? And and so that, some of the fuqaha of the subcontinent, they would write at the end of their fatwas, هذا الذي عندنا والذي عندنا غيرنا قد يكون أحسن وأولى وأجدر بالقبول. This is what we have to say. And what others have to say may be better and more deserving of following. But these are and then if you just look, and if one looks at the reality of riba and why Allah subhanahu wa ta'ala has prohibited it, right? This is, like what banks and financial institutions engage in is min akhbath al-riba, right? Because before, there's the scale of the ribawi enterprise was peripheral in societies, right? Which is why the church, for example, in the early Middle Ages, it was only a few hundred years ago, like the last 400 years, whatever the exact dates are, that they stopped excommunicating those who engaged in usury. Okay? And even why banks became called banks, etc. But now this is the central driver of not just societies at individual levels, but what is driving oppression, wars, fitna, fasad. This is all being financed by this grand ribawi enterprise. For to say Muslims can hug it, kiss it, and buy their homes with it is far away from even after, so that's that's what, and the threat of the devastating harm of it at the level of the individual, it can be seen by by dealing extensively with people who engage with it. That's anecdotal, right? Because law is not established by by spiritual insights, but when I was enjoying this Bedouin Sheikh Abu, he asked me, said, do the parents of these Westerners engage in riba? I said, why? He said, I've noticed, because there's masjid where a lot of Westerners used to pray. He says, I've noticed that these guys seem to have a lot of waswasa. They seem to be emotionally and psychologically off. I said, okay. He said, that's because of consuming riba. Because he says, do not read the Quran. And he's a Bedouin. I said, why? Because Allah subhanahu wa ta'ala says, that they don't stand إلا كالذي يتخبطه الشيطان من المس. They don't stand only as one who the shaitan drives crazy, makes them completely confused by his touch. In our day-to-day lives, if someone says, if you take that route, there's 5% chance, 2% chance that the highway will collapse and you'll be stuck. You wouldn't take a dangerous route, right? You'll be stuck there. There's a storm coming, and people exercise basic precaution. This is a matter where it's far away from any sense for a believer to engage in. Wallahu subhanahu wa ta'ala alam. We're going to have to pause here. There's something urgent that has come up. We're going to continue. Bi-idhnillahi ta'ala. We'll be sharing some readings related to this, and then we're going to start the section on huquq and istihqaq. So if you're in the course, stay tuned to the readings, and we'll look at rights that arise in sales, rights, and in the next part, bi-idhnillahi ta'ala. And then a very fascinating section on salam is coming up. Salam, and related to the manufacturing contract. Those are the two things we'll be looking at next week. And the salam also highlights principles, right? Because most of the later texts all mention that the least period of salam is 30 days, right? وأقله شهر على الأصح, right? And but this is not a textual matter. There's no primary text about this. But even actually, it's not even mentioned in Zahir al-Riwayah explicitly how long the salam is supposed to be. It is based on a specification arising from the urf, that what is the least need for deferral in such a transaction. Say the least need, i.e. customarily, is a month. That's neither textually established, nor is it something derived textually from Zahir al-Riwayah, from our Imams. And we'll see, and we'll give some readings related to that, but also post Hashit ibn Abdin, like in the Majallat al-Ahkam al-Adliya, for example, etc., they did not take the position of it being minimally a month. And there's good discussion. So we'll be looking at that. It highlights many principles related to how fiqh works as well. So we'll stop there. وصلى الله وسلم وبارك على سيدنا ونبينا محمد وعلى آله وصحبه وسلم والحمد لله رب العالمين.